Hello everyone, a very good evening to all of you. Welcome to the Officer Adda 24/7, the special session of your BRBL subject in the English medium language. So guys, we are doing the case studies question, okay? So let's start with the session. Number one question on the screen is that ABC company was incorporated under the Company Act 2013. Okay, so this company established under 2013 Act. However, it was later found that the company was formed with a fraudulent intention. The company with a fraudulent intention, the company is formed. The shareholder argued that since the company has been registered, it cannot be declared void. Okay, the shareholders say that the company has been registered because we know that for any company, registration is compulsory. It cannot be declared void. Now, class, can the company be declared invalid, and what provision of the Company Act apply in this case? Tell me, class. Can company be declared invalid, and what provision of Company Act apply in this case, class? Tell me. This is good question. You have to just tell me the one exact reason. Yes, class. Can company be declared invalid, and what provision of the Company Act apply in this particular case? So we can see that for any company, registration is compulsory. So as you can see here, guys, as per section, no need to learn the section. Okay, the company is formed providing the false and misleading statement. NCLT, that is National Company Law Tribunal, has power to cancel the registration and declare company as a void ab initio, because if any company established, their intention should be clearly mentioned. Is that okay? So in this case, they declare the company void ab initio, and additionally, person involved in the fraud may face the imprisonment up to 10 years and fine. So therefore, if the fraud is established, the incorporation of company can be declared invalid, because for every company, okay, for every company, we can easily say the object should be a valid one. Okay, the object should be the valid one. That's it. Okay, so this is the right answer. Then class, so this is the right answer for this question. Now let's move toward the next one. Okay, this A, B, C are partners in a firm. A takes loan from the third party X in the name of the firm without informing B and C. Later, the firm is unable to repay the loan. X file a case against all the three partners. So B and C is liable. A, B, C. A, B, C, okay. They have taken loan from the, who have taken, A have taken loan. A have taken loan. Now tell me, class, in that particular act, whether B and C is liable or not. Whether B and C will be liable or not, tell me the right answer. whether B and C is liable or not, because A have done the act without informing the B and C. So guys, if they have not informed the B and C, so in that case we can easily see that because according to the Indian Partnership Act, whatever act done by one partner, it will be assumed that all the partner have done the work. Okay, so that is given in section 4, so that's why all are liable. Okay, and that is also given here. You can see, according to Partnership Act, every partner is an agent of the firm and other partners for the business of the firm. If A took the loan for the firm business and it was within the scope of particular partnership authority, then B and C are also liable even if they were unaware of the loan. However, if A took the loan for personal reason, then the firm and the other partners may not be liable. Personal reason, suppose if A have took the loan without partnership firm name, in that case A will be personally liable. But in that case, the A have taken the loan in the name of partnership firm, so that's why all the partners are liable. Because what is partnership firm? The partners collectively are called partnership firm. That's it. Okay, so this is the right answer. Okay, this is the right answer for this question. Done, class? Now, next one. XY, what is this? XY start a partnership without a written agreement. X contribute 80% of capital, Y contribute only 20%. The firm make a profit of $10,000. X claim he should get 80% of profit. So is this correct? That is again good question. So here, class, they have started the partnership without a written agreement. See, whether the agreement is written or not, that doesn't matter. Okay, whether the agreement is written or not, that doesn't matter. X contribute 80%, Y contribute 20. The firm makes a profit itna. X claim 80%. That is not possible. Is this correct? The answer is no. Because if it is without any agreement, so we have to follow the term, that is equality. Okay, so in that case, the share will be distributed equally. Okay, as you can see here in the answer also, under partnership, if there is a no agreement, profit and loss are shared equally, irrespective of the capital contribution. Therefore, X and Y should each receive 5,000. Because we know that in the partnership, there is a partnership deed, okay, there is a partnership deed clause in which all the rules, regulations, terms are written here. Okay, so this is the right answer. Okay, so that's why XY should receive 5,000 equally. That is the right answer. Is that okay? Now let's do the next one. A offered to sell his car. A offered to sell his car. A offered to sell his car to B for rupees 5 lakh. B reply, I am willing to buy for 4.5 lakh. A refused to sell. But later on, B agreed to pay 5 lakh, but A refused to proceed. Can B enforce the contract? Can B enforce the contract to the A? Tell me, class. Yes, class, for this one, the right answer is, can B enforce the contract? The answer is no. The answer is no, class. He cannot enforce the contract because, as we can see here, no, B cannot enforce the contract according to the Indian contract. This is a counter offer. What is counter offer? See, there is a one word, cross offer, and the another word is counter offer. What is the difference between the counter offer and the cross offer? So, if we talk about the cross offer, A is offering to B that I will just sell my car for 5 lakh rupees, okay? And B, without knowing this offer, also offering 5 lakh to take car of A. That is cross offer. Same identical price. But in counter offers, the price of the offer will be different. First offer, second offer by second party. The second party is not accepting. He is also offering. Okay. So in that case, this is a counter offer. Okay. And the counter offer is the rejection of the original offer. So that's why it cannot be executed. Okay. So this is the right answer. Now, A 16-year boy take a loan of 50,000 from B and sign a contract agreeing to repay within 6 months. So later on he refuses to pay. So can B enforce the contract clause? Tell me. A very important question. Hanji class. A 16-year boy take a loan of 50,000. So if you remember a one famous case, that is Mohari Bibi versus Dharmodas Ghosh case. That is a landmark case in which it is held that any agreement that is done by the minor is totally void ab initio. So here can be enforce the contract? The answer is no. Okay, as you can see here, no, because if any agreement is done by the minor, so that is totally void ab initio. That is never valid from the beginning. So B cannot legally enforce the contract. This is the right answer. Okay, so this case is very famous and the landmark case that you have to remember. Now, Sarah buy a smartphone from the local store without checking its specification. After using it for a week, she realized that it does not support 5G, which she assumed it had. Can she claim a refund clause? Can she claim a refund? Can she claim a refund? Local store. And it is given local store. So in the local store, the buyer have to aware, not the seller. Okay. So the one legal maxim that is fit in this case is caveat emptor. Okay. As you can see here, no, under the doctrine of caveat emptor, it means let the buyer be aware. The buyer is responsible for checking the product before purchase unless the seller has misrepresented it. Since the seller did not claim the phone support 5G, Sarah cannot claim a refund. Okay, and you can also remember the one word that is caveat venditor. Okay, what is this? Caveat venditor. So this is the right answer. Done class? Now, next one. A well-known company advertised a fairness cream claiming that the user would see the visible result in 7 days. However, after using the product for a month, consumer noticed no change. One of the consumer Priya filed a complaint against the company. Now the question is class, how does the company protect consumer against the misleading advertisement and what action can be taken against the company? Yes, class, tell me. So first of all, this advertisement that to result within 7 days. That is totally wrong. Okay. So guys, in this case, we can see here that what should be the result. The Consumer Protection Act 2019, it's prohibit the misleading advertisement. Okay. It's prohibit the misleading advertisement and allow consumer to file complaint against the false claim which is made by manufacturer. So, but obvious, penalty or fine imposed on the company, ban on the misleading advertisement, compensation to affected consumer, and corrective advertisement to the rectify the false claim. So, this is the right answer for this question. Okay, this is the right answer for this question. Is that okay? Cool. Now the next one. Ramesh, a daily wage worker, met with a road accident caused by speeding car. He suffered severe injury and his family struggled financially. He filed a compensation claim against the car owner in a civil court, but the case dragged for a year. Later on, it referred to the Lok Adalat for the speedy action. So tell me class, how did Lok Adalat will help in that case? Just tell me the one answer. Okay, one statement. How did Lok Adalat help Ramesh in getting justice? And what are the advantage of setting such cases in the Lok Adalat class? How did this one? So guys, in this particular case, the Lok Adalat will help Ramesh by providing the quick and cost-effective resolution. Quick and cost-effective resolution. Since Lok Adalat follow the conciliation and negotiation method, both parties agree on a fair compensation without prolonged litigation. So why this Lok Adalat Ombudsman Consumer Forum is different from the court? Because as comparison to the court, it will take very less time. They do not have to follow the procedure just like the court. Is that okay? So here, advantage is speedy disposal, no court fee, binding decision, mutual agreement. Okay, so because of this one, this is the right answer. Now, Neha, a small business owner, received a check from a client which later bounced due to the insufficient fund. She filed a case under Section 138 of NI Act. The client requested the matter to be transferred in the Lok Adalat. So class, tell me, Lok Adalat will settle these types of cases or not? Lok Adalat will settle these types of cases or not? Please tell me. And how the Lok Adalat ensure a fair resolution in such financial dispute? So guys, if we talk about the check bounce case, so that is but obvious. The check bounce case involves a financial settlement which can be easily negotiated in the Lok Adalat. Is that okay? Because Lok Adalat facilitate the faster and hassle-free resolution. Okay, so this is the right answer. Okay, this is the right answer. Now, a small-scale enterprise took a loan of 30 lakh from a bank but failed to repay. The bank initiated SARFAESI proceeding. SSC Limited argued that being a micro, small, medium enterprise, it should be given protection under MSME Act and the bank should negotiate restructuring. Can SARFAESI can be taken against the MSME? And we know what is SARFAESI. SARFAESI means without intervention of the court. Okay, without intervention of the court, how the bank and financial institution can take money. So the question is very simple. Can SARFAESI take action against the MSME or not? Tell me, class. So can SURFACE be action against the MSME? So class, yes. SURFACE action can be taken against MSME if the loan secured class is classified as an NP, that is non-performing asset. Okay. And if the amount is above 10-20 lakh. Is that okay? Legal MSME classification does not exempt a borrower from SURFACE. This qualified the restructuring under RBI MSME. They also challenge the action before DRT if the procedure lapses. So remedies for this one is DRT, MSME Act, etc. Okay class, so this is all for today, and I hope so you people like this case studies question. We have a separate foundation batch. Till now we have already launched 5 batches. So if you want to take enroll, you can please enroll by applying the coupon code Y391 for the maximum discount. We have a separate subscription for the subject. We have a video course available. We have a mock test here. We have e-books also. We have a proper book, and we have a CAIIB ka Maha Pack also. So if you want to take CAIIB ka Maha Pack, again coupon code Y391 for the maximum discount.